it is the mind of this presiding officer to request both parties to submit the respective memorandum on this specific issue, not only for the information of the public, but for the guidance of this court as well. And this presiding officer will make a statement after everybody has spoken.
If Your Honor,
Mr.
please.
President.
Very willingly, we will comply, Your
May
Honor.
I just let the defense counsel first to finish?
Very willingly, Your Honor, we will comply. But may we request that we be given at least 5 days, Your Honor, in view of the importance of the issue involved, Your Honor.
Granted.
Thank you, Your Honor.
Granted.
May we ask for the same period as well, Mr. President?
Granted.
Mr.
Thank you,
President.
sir.
The gentleman from Pampanga.
Yes, on the issue of the memorandum, if you may also consider explaining to this court why you would consider subpoena or a subpoena of this court in the same category as a warrant of arrest or a search warrant. Please.
Yeah,
so that
definitely we will.
Thank you.
Definitely we will.
Yes, sir.
Mr. President, may we recognize Miriam Defensor Santiago on another issue.
This is a legal manifestation addressed to both panels. Gentlemen, you
The
may
gentle lady from Iloilo is recognized.
thank you. Gentlemen, you may
Tignan
take
mo nga
your
dito
seats.
yung-
In the first place, I don't understand why we are discussing a search warrant. This court has not issued a search warrant. What search warrant are we talking about? What we issued was a subpoena. Therefore, the issue should be, what are the effects of the subpoena, considering that when the subpoena was requested for by prosecution, it attached what purported to be bank documents, but immediately the prosecution disavowed any knowledge of the authenticity of the document. Therefore, the issue is, can counsel in any proceeding attach to his request for subpoena a document about which he knows nothing? That's the issue. Hindi mo pala alam kung ano yun eh. Bakit mo sisingilin kami na issue kami ng subpoena? Eh ano yun? That's only a scrap of paper. Why are you doing this to the court? Why didn't you go hit your law books? So kung ano-ano mga pinagsasabi nyo ah. Hindi naman ito kursunada eh. Siguro ito sa jurisprudence. Dito sa inyong supplemental request for subpoena / reply dated February 3, paragraph 11. I will start even earlier. Paragraph 10. Recently, an anonymous source provided the prosecution with photocopies of what appears to be PS Bank documents without more. Pwede na ba yon sa korte? An anonymous source told us. So we're alleging it in our request for subpoena. Is that allowed? Can you allege something in open court or even in a written pleading with a court that you have information, but it is based on an anonymous source? My goodness, if you bring this to any trial judge in the entire country, particularly in Metro Manila, you'll be cited for contempt. I know that I said that impeachment is quasi-judicial and quasi-political, but you cannot tamper with the rules of court which are suppletorily applicable to our rules of the Senate on impeachment. Saan ka nakakita ng pleading na somebody anonymous said like this to us, so we're going to ask the court to do something? What kind of respect for the Supreme Court are you entertaining in your minds? Pangalawa, basahin ko sa inyo, this is a very, very strange, bizarre document. Imagine telling me if I were a trial judge, an anonymous source told me, Your Honor, that something happened, so will you please issue a subpoena? Can that be a basis for issuance of subpoena? Paragraph 11. Moreover, it seems that the media itself also has information. Kailan naman ng judge pwede mong hikayatin o pwede mo pakiusapan na gumawa ng kung anong mga aksyon na gusto mo, issuance of a subpoena on the basis of a media account? My goodness! Is this government by media or is this judicial system by media? Again, this is a ground for contempt. If I were trial judge, I would say you're wasting my time. Sheriff, take him to city jail. Direct contempt yun eh. Biro mo, if you're going to the court in a serious frame of mind, you're met by this kind of a pleading. May narinig kami sa isang babae na hindi namin masabi kung sino yon. May nabasa kami sa dyaryo. Opposing counsel in all trial courts of our country will go apoplectic objecting to that kind of a request. May just point that out to those people who have never been to trial court. Paragraph 12. While it cannot vouch for the authenticity of the said documents, the prosecution believed that it is its duty to submit the documents to this court as they may have a bearing on the court's resolution of the pending request for subpoena. Huh? Say again? 1, I heard someone who I cannot identify say something. Number 2, I read it in the media. Now, it is my duty to bring it to the attention of the court. Duty my foot. It is not your duty. It is your liability. That is disgrace to the judicial system. And I have basis for saying that. I will read you the case. In these cases of false or fake documents, which yesterday the bank manager asseverated, she said, that's a fake document. In the case of fake documents introduced in court, here is what the Supreme Court had to say. Based on administrative cases against certain judges. An administrative case is a case for disbarment. Ganon katindi. Pag nagbigay ka ng peke dokumento, peke na testimonya sa korte, ganon katindi yan. Pwede yung base na ipa-disbar mong abogado. There are 2 cases. One, where the lawyer himself did not know that the document was false, did not participate in its preparation. And the other is where the lawyer willfully introduced what he knew to be fake documents. Let's talk about the first instance. The lawyer willfully knew the document was fake. Here is what the Supreme Court said in Samala v. Valencia. I beg the indulgence of this court. I'm hyperventilating because I'm very, very upset. I will leave this court immediately because I'm sure I have hypertension. Samala v. Valencia, 512 Scra. 1, decided in 2007. Here is what the Supreme Court said. Respondent cannot feign ignorance of the fact that the title he submitted was already canceled. In other words, the Supreme Court is saying, we are concerned, we are aghast that the lawyer knew that the document he submitted was false. Respondent failed to comply with Canon 10 of the Code of Professional Responsibility, which provides that a lawyer shall not do any falsehood, nor consent to the doing of any in court, nor shall he mislead or allow the court to be misled by any artifice. It matters not that the trial court was not misled by respondent's submission. Notice the court said, even if that false document did not mislead the court, still the lawyer is liable. Because the burden should not be placed on the court to determine whether the document is true or not. It is the duty of the lawyer who is introducing it. It matters not that the trial court was not misled by respondent's submission. What is decisive in this case is respondent's intent in trying to mislead the court by presenting this document. That's what the Supreme Court said. If the lawyer willfully introduced fake document, the Supreme Court will condemn the lawyer. I will see what the penalty was. Accordingly, the court finds the lawyer guilty of misconduct and violation of Canons 21, 10, and 1 of the Code of Professional Responsibility. He is suspended from the practice of law for 3 years, effective immediately upon receipt of this resolution. That is a decided case. It binds us all here. But that is in the case of a lawyer who knowingly and willfully introduced a fake document. Now let us grant the presumption of innocence to the prosecution panel. Suppose they did not know, as they indeed said in their pleading, they could not vouch for the authenticity of the document. Do they still have any liability? Yes, said no other than former Chief Justice Enrique Fernando, one of the most brilliant lawyers produced by this country. Justice Fernando wrote, in the case of Berenguer v. Carranza, 26 CRA, (26 CRA 673), promulgated in 1969. The lawyer had, in the preparation of the fake document, the lawyer had nothing to do with it. And therefore, the charge of deliberate deception obviously cannot be sustained. But, the court went on, would that of itself entirely exculpate him from any responsibility? The answer must be in the negative. Maski hindi mo sinadya, maski hindi mo naintindihan na peke pala yon, pag na-introduce mo yan evidence at natuklasan na peke pala, ay may pananugutan ka pa rin pala. As was correctly pointed out in the complaint, his failure to exercise greater care did result in the confusion and prolongation of the suit. Kasi nalilito kami eh. Under the circumstances, it would be to err on the side of undue leniency if he would be held blameless. He had incurred liability. His fidelity to his oath as attorney was less than entire. Every member of the bar must be on his guard, lest through oversight or inadvertence, the way he conducts his case or the evidence he presents could conceivably result in a failure of justice. Even if there be no intent to deceive, therefore, a lawyer whose conduct, as in this case, betrays inattention or carelessness should not be allowed to free himself from a charge thereafter instituted against him by the mere plea that his conduct was not willful and that he has not consented to the doing of the falsity. The Supreme Court found him guilty and issued a penalty of reprimand with a warning that repetition of the offense will be more severely left with. This is the ruling of the Supreme Court. Pinalitan na ba natin itong mga ruling na ito? Pwede na pala ngayon, maski media ka, pwede mo nang i-narrate sa korte na hindi mo naintindihan kung tama yun o totoo yun o binigay yan ng PR, ng Dirty Tricks Department na kung sinong PR firm. Come on! Wake up! We all know how politics is done in this country. Just because you admit that this is a quasi-political proceeding does not mean that we can turn this into completely political circus. Kaya, I submit to my colleagues, I respectfully submit to these colleagues, my colleagues, what is the role of media while this trial is pending, while this trial is sub judice? Pababayaan na lang na ba sila na magbibigay ng kung anong lead dyan na identify tayo isa-isa. Itong mga senador na ito, pro-Aquino ito. Ito naman, pro-Corona. What does it say of our integrity? Pabayaan lang ba sila? Libreng-libre ba sila in the name of freedom of the press? I think we should think very carefully about the sub judice ruling. While a case is pending in court, there is a gag rule. No person may orally or through other means, by media, for example, comment on the merits of the case. Even we are not allowed to do that. Shall we allow media to do that? Nilista tayo isa-isa, dito kaliwa, dito sa kanan. May kaso dito Ay di kung ganun pala, if this is going to be trial by publicity, let us invoke the Constitution and ask for a change of venue. Perhaps out of the country. We all know that the Constitution itself recognizes that public opinion can be so prejudicial in a pending trial that under the Constitution, the Supreme Court may order a change of venue. Ganon katindi ang ayaw ng korte ng is public opinion that will teach lawyers who have trained for 9 years to become lawyers on what the law is or how it should be applied. by people who have never applied the law in trial court. Kung ganito ito, huwag na tayo magbasa pa. That is all, Your Honor. Thank you.
Thank you. Now, may I now state the position of this humble presiding officer, and this position is subject to the opinion of the court, of the Senate sitting as an impeachment court. The Senate, it is the humble view of the presiding officer that the Senate as an impeachment court must at all times observe the rule of law. It cannot transgress any of the applicable provisions of the Bill of Rights. It must be guided by the presumption of innocence before the pronouncement of guilt. It must at all times observe the principle of procedural and substantial due process. It cannot use